Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Today is Tuesday, September 30th, 2025. Come on in, smash the like button, leave your drama at the door. Thank you so much for playing and have a nice day. We got a lot to get to today. We got a lot. You're going to see me 3 times today, if you so choose. 3 times. Today, I'm going to tell you what I'm going to do, and then I'm going to do it, and then I'm going to tell you what I've done, because I learned from Alessi. The first thing we're going to do is there are 17 motions in limine that were filed by the Commonwealth on the Brian Walshe case. The final pretrial conference is scheduled for next Tuesday, October 7th, and I do believe that that is the day that all of these motions will be heard. I've also just found out, thank you, Kyle Sharkey, who's always a wealth of information, that there are a number of defense motions in lemonade, we call them, because the closed captions did that one day, and so we adopted that phrase. The defense filed a couple as well today. I just don't know if they've been scanned yet. So just as a heads up, just because you see something on the docket in Massachusetts doesn't mean that it's yet been scanned into the system. But as soon as it's scanned, then we will go over the defense motions as well and any oppositions, and then they're gonna argue them next Tuesday. And then at 12:30 today, we are going to go over the supplement to the mega motion that was filed yesterday, I think it was filed yesterday, last night at some point. Grant's deposition was postponed. I told you that was going to happen. So we'll do that at 12:30. And then at 6 o'clock, I'm going to go on Justice Served TV with Linda Kenny Bodden and Michael Bryant. I guess they're doing interviews this week. They did Aiden Carney Turtle Boy last night. Tonight is me. So I'm going to just teleport you everywhere. You don't even have to remember or do anything other than set the reminder once I teleport you there. Free turtle dove. Thank you. There's something, the full moon, I think, is not scheduled until, because I really did look that up. I think the next full moon is like October 7th, I want to say, because, the world has gone crazy. The next full moon is 7 days from today. So I don't know. Listen, I try and stay out of it. I don't know what's real, what's not real. We went over, thank you, Miss Dad. We went over a whole story yesterday on Tilly Norwood. Tilly Norwood is an AI actress. She's completely made up of AI. A million talent agencies apparently want to sign her. Who knows what's real, what's not anymore. I try and stay out of it because I'm a busy person and I'm a mother and I got a hell of better things to do with my time than get neck deep in the mire. They go back for the Proctor files on the same day, October 7th, but that's in front of Judge Krupp. And the pretrial hearing or conference or whatever they call it is on Walshe, and that's in front of Judge Freniere. And she is sitting right now in Plymouth. So I don't know. I have to look in the court docket to see what the habeas says about where Brian Walshe is going to be brought on October 7th to tell you what court it's going to be in. I don't know if you want to go, but I don't know. All right. So we got to get right to it because we got things to do. We got a schedule here. We're on an agenda. My mind does not have time to wander because we got lots and lots and lots of things to cover. Welcome, Amy 1111. Those are angel numbers, and she became a member, and I think you're going to like it here. All right, here we go. This is in the Commonwealth versus Brian Walshe, which, as you know, is specially assigned to Judge Diane Freniere. Originally, when we first started covering this case, I believe it was assigned to Judge Beverly Cannone. And then when Judge Cannone was rotated out, she was assigned to keep Karen Reed, and then Brian Walshe and I believe Harry Turk and a couple of other cases were assigned to other judges. But here we go. All right, so this is the Commonwealth's motion in Lemonade number 1, and this is just a basic motion to provide the jury with a means to review electronic exhibits during deliberations. The Commonwealth is asking that the jury is allowed to bring a laptop computer or something similar into the jury room so that they can review any evidence that was entered into the trial while they are backstage deliberating. Okay, that's number 1. I expect that would likely be agreed to by the defense and granted by the judge. Commonwealth's motion number 2 is a notice. Commonwealth would like notice. They move for an order that the defense identify in advance any visual aids the defense intends to display during opening statement. We saw that also in the Karen Reed case. We see that in practically every case because the Commonwealth wants to make sure that the defense isn't going to show something in their opening that is not admissible at trial. And so that is something that is typically granted. Mass Dad is in the chat here. He is a whiz when it comes to Massachusetts law. I'm sure that if he's not too busy, he'll answer your questions if you have them, because it is impossible for me to read the chat while I'm also reading to you. I'm not that good of a multitasker. Motion in Limine number 3 is notice of any third-party culprit evidence. This is interesting because I have not been made aware of during all of the pretrial shenanigans any evidence that the defense intends to use a third-party culprit defense. However, if they do want to use one, the Commonwealth is asking that the court require in advance of trial that the defendant give notice of any third-party culprit evidence that he intends to elicit. And that is pursuant to Massachusetts Guide to Evidence, Section 1105, which provides evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that A, the evidence is relevant, B, the evidence will not tend to prejudice or confuse the jury, and C, that there are other substantial connecting links between the crime charged and a third party, or between the crime charged and another crime that could not have been committed by the defendant. We saw this in Karen Reed. We saw Judge Cannone rule that Karen Reed, her defense, was allowed to introduce evidence of third-party culprit in trial number 2 with regard to only Brian Higgins and Brian Albert, and that they were not allowed to introduce any evidence with regard to Colin Albert. We also saw this. Well, let's go to Indiana for a minute, shall we? That's where the Delphi case was. Richard Allen. That judge, Judge Fran Gull, decided that she was not going to allow any evidence in with regard to any third-party culprit defense, when in my opinion, and if you were watching my coverage during that trial, there was substantial evidence of a potential third party or third parties that I thought could sway a jury, but that Judge Gull did not allow any of that in either. Okay. DW says, do you ever have a case like the Commonwealth versus Walshe where you want both sides to lose badly? I can't really think of one. Usually it's easy for me to pick a side, right? Usually I have no problem picking a side. The only thing that happens from me sitting on a fence is that I get splinters, and I don't like splinters. But in this case, I think the judge's decision about not suppressing the evidence from Brian Walshe's what I believe to be an illegal search of his phones that was outside the consent agreement. Yeah, me too. The only side I ever want to win is the side of justice. So I completely disagree with Freniere's decision to allow this evidence in, even though he may be completely guilty. Maybe he's not. If he is guilty and he did make those Google searches, Brian Walshe, those are the dumbest Google searches on the face of the planet. Really? How to dispose of a 120-pound woman's body if you really need to? Really? Best tools for taking apart someone's body? Really? I mean, is that really what a guy like him is going to Google? I mean, he was smart enough, if you want to call it that, to defraud an Andy Warhol collector by selling him an $80,000 fake Andy Warhol painting on eBay. So do you really think, so I don't know, but I think that decision was wrong. I think the SJC was wrong to not allow it to go up before this trial, because this is what they do in Massachusetts. Kind of like, don't worry, if he's convicted or when he's convicted, he can come back and appeal it later. No big whoop. Let's just waste ton of taxpayer money, ton of judicial time and resources, and let's just not hear the issue now, because why? I don't know. And so I'm on the side of justice here, and I do not think that was the right decision. And I think it could lead to a conviction, which in this case would be wrong, because it is better that one innocent person go free than one. Wait, no, I always say that. Why do I always say that backwards? It's better for one guilty person to go free than for one innocent person to spend any time in prison. And so, listen, if the police and law enforcement cannot properly conduct an investigation that doesn't violate the defendant's civil rights, then that's a problem. It's a problem, and they need to be spanked. And until something like that happens, they're not going to, why should they ever change if there's never going to be any ramifications for their behavior? And we're watching this right now. We're going to cover the appeal of Dennis Bateman, who is a guy that's been in jail or prison, I should say. He was convicted in, oh boy, tell me when, 2007. And we're just finding out now because we're going to do his appellate briefs and we're going to cover his appeal. This is also in Massachusetts, that the Commonwealth withheld evidence and withheld, I think, a potential exculpatory witness and, the jailhouse snitch. And I haven't read the whole entire thing yet, so I can't tell you a lot about it. But we're going to watch this argued in the SJC. I think it's October 14th. And we're going to go over the whole case before that. But listen, people who live in Massachusetts will tell you that this stuff has been going on for decades. It didn't start with the Karen Read case. It's not going to end with the Karen Read case. And keep in mind also that Ana Walshe's disappearance, this is a no-body murder case, by the way. Ana Walshe's disappearance was 1 year after the murder of John O'Keefe, okay? So whatever drama you're reading out there, whatever stuff, whatever extraneous stuff that, like, taking up space in your head right now because it's being spewed all over the internet, with regard to Karen Read and her case, at the end of the day, John O'Keefe was not hit by a car. A car did not hit John O'Keefe. Karen Read has been acquitted, and Turtle Boy is still being prosecuted and facing 100+ years in jail for allegedly intimidating the witnesses from the Karen Read case, who are potentially the people who conspired to put him in jail, and also the people who potentially had something to do with the cover-up, maybe, or conspiracy towards Karen Read. And there still hasn't been justice for John O'Keefe because nobody, apparently, so far is going to face ramifications for that murder. So at the end of the day, just put all that noise out of your head, because that is still the reality of the situation. Okay, thanks for coming to my TED Talk. All right, moving on. I don't know that they've ever discussed, Mastad, do you, a third-party defense, third-party culprit defense in Walshe? I can't recall. Mastad says, fun fact, Bateman's attorney, Dennis Bateman's attorney, Cannone, worked in Rosemary Scapiccio's office many years ago. Well, that tracks. And you know what? If she was, let's say, mentored by Rosemary Scapiccio, then that should be a really fun SJC oral argument to watch. And they always do broadcast live, SJC. So it's going to be good because we love Rosemary Scapiccio. All right. So the court has the discretion to rule in advance of trial whether the defense has made an adequate showing of third-party culprit. I don't know that they're going to do that, but the Commonwealth is also right on this motion, and that will likely be granted. Yeah, there has never been a third-party culprit brought up in Walshe. Okay, thank you. Moving on. Like, Mass Dad knows everything, about every single case that's happening in Massachusetts. He works in the legal system. He's originally from Long Island, and when I started covering this Dennis Bateman case yesterday, I'm like, have you heard of this? And he's like, all of a sudden, he like sends me like 1,000,000 documents. He's like, oh yeah, and here's the trial transcript too. So he's up on everything. Next, Commonwealth's motion in limine number 4 for notice of any proposed reputation testimony. This is also a very common motion. And the Commonwealth is moving that the court require the defendant to identify in advance any witnesses who will be asked to offer evidence opinion about the reputation of any person, including defendant Brian Walshe, victim Ana Walshe, and there's a footnote there, which we'll go to in a second, any friend, associates, or coworker of Ana Walshe. Well, I can tell you right now, they may have some reputation evidence with regard to the guy whose name I can't recall right now, who was allegedly having an affair with Ana Walshe in Washington, D.C. Any investigator or law enforcement officer, any expert witness, any law enforcement or investigatory agency, and any person appearing on the Commonwealth or defendant's witness list. And further moves the court to conduct voir dire of any such witnesses to determine whether a proper foundation exists for such evidence or opinions before the jury hears them. This is another motion that we saw in Karen Reed's case, trial number 2, because there was a bunch of stuff swirling around the cesspool of Twitter about Richard Green. And Richard Green was an expert witness in the Karen Reed trial, trial number 1. They wound up not calling him, right? They didn't call him in trial number 2, correct? And somebody out there had dug up some old police report about him being in a bar fight after his father died. And, you know, this is the kind of stuff that they want to prevent surprise, and they want to decide in advance of the trial, in advance of somebody blurting something out on the stand, whether or not it is admissible. And so this is also a common motion that should also be granted, and both sides should comply with this. It says here, while a defendant may present evidence of a good reputation with respect to the elements of the crime charge, the evidence cannot be brought in the form of private opinion. All right, here's footnote number 1, which was after victim Ana Walshe's name. And it says the Commonwealth intends to elicit testimony that Ana was a dedicated employee and not the type of person who would not show up to work, as evidence tending to show that she did not voluntarily disappear. The Commonwealth also intends to elicit testimony that Ana was a loving mother who would not have abandoned her 3 children. Well, think about all of the ways that the defense could counteract that by calling witnesses who say, you know what? Actually, and I'm not victim blaming here, I'm just telling you what the facts are from the court documents. Actually, Ana didn't come home for Thanksgiving. I think it was Thanksgiving she didn't come home for, right? Because she was in Ireland with her side piece. And also, I think it was Ireland. And also, she didn't show up home on Christmas Eve either. And she was kind of missing. And so I'm sure that they are going to counteract that with evidence of their own. So there's that, in my opinion. And also they're going to use, I think, her affair as evidence that she may have run away with this guy. Maybe she's still alive somewhere. I don't know. I don't really know what their defense is going to be because they haven't told us much yet. And so they are just asking that the defendant establish the appropriate foundation, and that too is also a proper motion. Motion in limine number 5 by the Commonwealth is to allow in-court identification of the defendant. We've seen that in many, many trials that we've watched where the state or the Commonwealth asks that, hold on. Ask that the witnesses are allowed to point to the defendant. Do you see the defendant in the courtroom? Oh, yes, I do. And could you tell us what the defendant is wearing, or can you point them out? Yes, that's her right there, sitting next to Alan Jackson and David Yannetti. They've done that a lot. It's commonly granted. And so I don't see any issue with that. And then they go on to talk about the law. But since we're here, and this is in motion number 5, let us look at the summary factual background as set forth by the Commonwealth. Once again, for those of you who are not familiar with the case, you can glean some information here. And we do have a whole playlist on Brian Walshe, but today we had to just jump right in. All right. On January 4th, 2023, Ana Walshe's employer called Cohasset police to report that the defendant had reported Ana Walshe missing. So remember, Brian Walshe didn't call the police. He called her employer to say, have you heard from her? Because I haven't heard from her. She was splitting her time between their rented home in Cohasset and an apartment or a townhome, or I think it was an apartment that they owned in Washington, D.C. And she was in real estate. There were also some shenanigans going on at that apartment complex where she lived part-time in Washington, D.C., that had to do with some people pretending to be with the FBI and stuff like that. That is a whole side rabbit hole that you could fall into if you like. A Cohasset officer was dispatched to the Walshe residence. The officer spoke with the defendant and gathered information to complete an NCIC missing persons report. That officer and another returned to the Walshe residence that evening and interviewed the defendant in a recorded interview. Remember, too, that there are many players involved in the Ana Walshe investigation and the Brian Walshe trial that were involved in the Karen Reed case. For example, Bukhenik, Fanning, Proctor, and others. Cohasset police and the MSP troopers returned to the home on January 5th of 2023. Interviews of the defendant and his eldest son were conducted. Footnote number 1. The defendant's mother was present when police spoke to the eldest son. It's important to point out here, the eldest son was 6 years old, and he was interviewed by Yuri Bukhenik. Whether that is proper is I could do a whole show on that, but law enforcement is supposed to be specially trained to interview children, and so there's that. We've been over this at length in other streams. Police conducted additional searches for Ana Walshe at the residence and repeatedly interacted with the defendant to gather information as they searched for Ana. And remember, he gave them permission to search the house and his car. The Commonwealth seeks to elicit identification testimony from officers who interacted with the defendant in January of 2023, FBI agents who interacted with the defendant, and Ana Walshe as part of a federal investigation unrelated to the offenses for which the defendant is on trial. So I guess they're intending to introduce some evidence of his unrelated crimes regarding the Andy Warhol paintings. I don't know if there's been a determination whether that's going to be admissible yet. Family members, friends, the landlord, and business associates who interacted with and were familiar with the defendant prior to the events for which he is on trial. Discussion. And I'm not sure, actually, if in these 51 pages there's a witness list yet. I'm not sure if I have it, but I'll look. And then they talk about the law. First-time in-court identifications by eyewitnesses shall only be admitted as evidence if there's good reason for their admission. And there's 2 reasons why a good reason might exist. Number 1, the eyewitness was already familiar with the defendant before the commission of the crime. And 2, the witness is an arresting officer who was an eyewitness to the crime. And the identification would merely confirm that the defendant is the person who was arrested for the charged crime. And so it'll be interesting to see defense's opposition, if any, to this. It says witnesses who will be asked to make an in-court identification of the defendant will be people familiar with him prior to January 1, 2023, FBI agents who interacted with him during the federal investigation, or police officers who interacted with him from January 4th through 8th, 2023, civilians. And here they are. So this is going to give us some insight into their witness list. Joseph Cesar's the manager at Vinon Liquors, footnote number 2. The manager of the Vinon Liquors was familiar with Brian Walshe and had spoken to him on a number of occasions prior to January 1st of 2023. The manager identified Brian Walshe as the person going to the dumpster on January 1, 2023 in the surveillance video from Vinon Liquors. Lay witness opinion regarding identification from surveillance is admissible if witness is more likely to correctly identify the individual from the photograph than the jury. So I'm guessing that the video is grainy and it is going to be difficult for the jury to be able to see if that's Brian Walshe in the video. But for some reason, the liquor store manager is able to identify Brian Walshe from the video, surveillance video. Okay. Alyssa Kirby, family friend. Peter Kirby, family friend. Jem Mutlu, family friend. Robin Howe, the nanny, footnote number 3. The nanny was employed by the Walshe family and interacted with Brian Walshe regularly. She saw the defendant leave the family home with trash bags he had retrieved from there's a word missing there. She saw the defendant leave the family home with trash bags he had retrieved on January 3rd, 2023. From where? Jesse DeVoe, business partner, Fresh Pulls, P-U-L-L-Z. Julie Bassler, KinderCare. Peter Capazzoli, landlord. We know because Capazzoli sued Brian Walshe's mother because she was the one on the lease for this place that they rented on Justice Cushing Highway. I think that's the name of the street. And we know because we went over the lawsuit in which the landlord sued Brian Walshe's mother for all of the damages incurred by the police in executing their search warrants in his home. I want to know if he's got photographs. Hold on. Nancy McAloon, insurance agent. Peter Salvaggi, financial advisor, insurance agent. And then law enforcement, footnote 4, which says, Officer Lawrence, Sergeant Schmidt, and Sergeant DeChico were present when the defendant lied to police. There it is, DeChico. Someone else who was involved in the Karen Reed case. Greg Lawrence, Cohasset Police. Harrison Schmidt, Cohasset Police. David DeChico, MSP. John Fanning, MSP. Yuri Bukhenik, MSP. Randy Bellinger, Cohasset Fire Department. And from the FBI, Kristen Koch, Matt Rippertella, and Tyler DeLorme. Conclusion. Because these witnesses were not present during the commission of the murder, and there's also good reason for these in-court identifications, the defendant bears the continuing burden to show that in-court identifications would be unnecessarily suggestive. The defendant cannot meet this burden. XOXO, Greg Connor, who will be trying this for the Commonwealth. He's the top dog over there at the Norfolk DA's office. Commonwealth's motion in Limine number 6 to preclude reference to or introduction of irrelevant conduct of testifying and non-testifying police officers and agencies. So in other words, we don't want you talking about what a crook or what a bad cop or what a dishonorably discharged, biased, incompetent officer Trooper Michael Proctor was. Trooper Michael, former dishonorably discharged Trooper Michael Proctor was. So let's listen to why. Commonwealth moves for an order prohibiting commentary, argument, evidence, or examination regarding internal affairs investigations, discipline, or related matters of any police department, the Massachusetts State Police, or any potential police officer witnesses, including Sergeant Bukhenik, Trooper Connor Keefe. Connor Keefe also was involved in the Karen Reed case. Detective Lieutenant E. Keefe, so there's another Keefe, and I wonder if he's related to Connor Keefe. Former Trooper Proctor, well, at least they say former. Detective Lieutenant Tully, oh, Tully's here too. The gang's all here. Whether or not the officer testifies, as such prior conduct is neither admissible nor relevant. Well, here's where we differ. I think it may be very relevant, and depending on what is found in those text messages and communications of Proctor that they're still fighting about, and we're waiting for Casper the Ghost, the judge in the federal court, to decide whether or not it can be released to the defense, because ADA Lisa Beatty has told Judge Krupp that yes, indeedy, some of these things are relevant to the defendants, including Brian Walshe, Miles King et al. Who knows what they're going to find in there with regard to Proctor. Footnote 1 says the Commonwealth has disclosed conduct involving potential police witnesses that the Commonwealth does not expect to call and requests leave to address such conduct if necessary. I think it's coming in, but we'll see. Commonwealth admits there's a narrow exception where special circumstances in the interest of justice forbids strict application of the rule. A judge has discretion to determine whether the credibility of a police officer is a critical trial issue and whether prior false statements in a separate matter may have an effect on the result of the trial, so that the evidence should be admitted in the interest of justice. We know judges have wide discretion. Factors to be considered include the age of the prior misconduct. Well, Proctor's misconduct in the Karen Reed case was very close in time to the disappearance of Ana Walshe, within a year. In fact, I think it was August 2022 when Proctor was looking through Karen Reed's phone saying no nudes yet to his buddies. So that was 6 months before he started looking through the phones of Brian Walshe. So there. The age of the prior misconduct, the strength of the evidence of the misconduct, the simplicity of establishing the misconduct, and whether the misconduct is probative of how a police officer conducts police investigations. Well, he was fired for it. If the misconduct would not have been admissible due to its age, had it resulted in a criminal conviction, it's likely inadmissible. See if they have any. Here it is. The Commonwealth is not calling former Trooper Proctor, whose role in this matter was described in the Commonwealth's opposition to the defendant's motion for Rule 17 summons for records from the MSP Division of Standards and Training, an officer of professional integrity and accountability, docket number 58. You know, it'd be really good if they did. Put hyperlinks in there so the judge can just click right to it and doesn't have to go look it up on her own. Anytime you make more work for a judge, it doesn't make them very happy, or at least attach it as an exhibit. But I don't know. They didn't ask me. As to officers that the Commonwealth may call, their conduct did not involve untruthfulness. Well, you better be careful if you call Tully with all the stuff that's coming out in Aidan Carney's cases about what he did behind the scenes, like making up a fake grand jury subpoena. Well, that goes to truth and veracity, don't you think? There has been no suggestion, nor is the Commonwealth aware of any allegations of misconduct as it pertains to this defendant's case. Well, not yet. Former Trooper Proctor's conduct and text messages in an unrelated investigation are not relevant to any issue in this case. Former Trooper Proctor's role has been documented. Other officers were present at the interviews. Witnesses have testified or been re-interviewed. Oh, that's rich. And former Trooper Proctor will not be called to testify by the Commonwealth. Well, of course, because he would be excoriated on the stand. How can you? The Commonwealth also moves to preclude a reference to a federal investigation into an unrelated 2022 investigation in Norfolk County. The U.S. Attorney's Office informed the Norfolk District Attorney's Office that the federal investigation was closed. No charges were reported. Well, yet. The Commonwealth also seeks an order precluding reference to or examination about any internal affairs investigation, discipline, other investigation or sustained findings of non-testifying police witnesses. Where a witness does not testify, their credibility is not a critical issue, and reference to any findings would constitute hearsay. Well, that is one that will be exciting to watch the argument of next Tuesday. But I don't really know if they can argue it next Tuesday because they still don't have the release of Proctor's communications. They might have to table this until closer to trial, in my opinion. Commonwealth's motion to limine number 7, to preclude reference to any alleged bad character or bad reputation of the victim or any witness, and 2, any alleged prior bad acts of the victim or any witness. Footnote 1. A separate motion regarding testifying and non-testifying police witnesses has been filed. We just read that. The Commonwealth moves in limine for an order that the defendant may not, during opening statements, cross-examination of witnesses called by the Commonwealth, direct or redirect examinations of witnesses called by the defense, or in closing argument, make any reference to 1, any alleged bad character or bad reputation of the victim or any witness, and 2, any alleged prior bad acts of the victim or witnesses. You know what this reminds me of? This reminds me of, I don't know, the most uncomfortable witness that I ever think I've seen on the stand, who was called during, oh, what's this coming off? During Harry Turk's trial. Do you remember his friend? What was his name? Kurt Pfannenstiel. He was on the stand being cross-examined about his messages with Dr. Turk's late wife, Katie McLean. Remember? That guy was so uncomfortable. And it was all allowed in because I think the claim was he was trying to get with Katie McLean. Let's see what it is really that they're trying to get at here. Well, they're not giving any actual examples, but I think all of the examples that I provided you earlier with apply here. The fact that Ana Walshe was having an affair with a guy in Washington, D.C., the fact that she went with him to Ireland over Thanksgiving and didn't come home, the fact that she went missing like on Christmas Eve, and the fact that, I mean, if he's called to the stand, all of that stuff can come in. And I can't recall any other witnesses that are going to testify here off the top of my head. But let's say they call somebody from the building, right, where she was living part-time. Can all that stuff come in about that investigation down there, about the fake FBI guys and how Ana Walshe was involved in that? We'll see, but he's not giving us any examples. So that's the end of that one. And here we are, Commonwealth's motion lemonade number 8, to admit photos of digital devices rather than actual devices. Commonwealth anticipates, did my chat just like stop? My chat just stopped. I got to go out and come back in. Like, I'm still live, right? Because when I even try and click into my own video on my phone, it says that this happened already 5 hours ago. I don't know. YouTube is like doing so many crazy things. Sua sponte, and I don't like it. Murray, you just missed it. I already went over that. I went over that motion regarding law enforcement, so you might want to rewind a tad if you want to be if you're interested in that. Yeah, it froze, right? Okay, wasn't just me. Commonwealth anticipates that information obtained from digital devices, including cell phones, tablets, and laptop computers, will be admitted into evidence. Yes, we know about the son's iPad, where all the Google searches were found, and also Brian Walshe's cell phone and other devices. The Commonwealth moves for an order that rather than admitting the physical device, the Commonwealth may enter photographs of the devices. Well, where are the devices? Why don't you have the devices? Where are they? I don't know. That raises my little spidey senses right there. Did you lose them? Were they left unattended? The way that I think it was Guarino testified, Guarino or Connor Keefe, when we watched the evidentiary hearing on this specific case, that Connor Keefe plugged in the devices to Gray Key and left them overnight unattended and then came back in the morning. Are all the devices lost? Because they know that they were returned to Brian Walshe within 18 hours and then seized again. So where are they now? That's weird, right? As grounds, digital devices likely contain data beyond which investigators were permitted to examine, could be manipulated by the jury, and the significance is the extracted data, not the device itself. I don't remember seeing this motion in the Karen Reed case, so I don't know why they're making it, but I'm like, I don't remember seeing this as a motion in limine in any of the prior Norfolk County cases that we've covered, and we've covered quite a few. I feel like Harry Turk, Penny McGee, and others. Commonwealth's motion in limine number 9 to admit defendants 4 recorded interviews with police. Well, see, here's the thing. In Brian Walshe's case, they recorded all of his interviews. Can you imagine? Footnote number 1, the Commonwealth intends to introduce additional statements of the defendant that were not recorded. All statements have been provided to the defense. Commonwealth moves in limine for a ruling that it may introduce transcripts and play audio recordings of interviews between the defendant and police officers on January 4, 5, 7, and 8 of 2023. The audio recordings and transcripts of these interviews were introduced at the hearing on the defendant's motion to suppress the consent searches of digital devices. Yeah, go back if you didn't watch that. That was a really interesting hearing that we covered, and Yuri Bukhenik testified, and his demeanor was so much different than it ever was in front of Judge Cannone. And also, I think it was Fanning who testified that he just drafted a police report last week. This was a 2025 hearing, but he backdated it all the way back to January 2023 because, that's what they do. Footnote 2 says all the Commonwealth's motion to impound the recordings and the transcripts was allowed. Interviews 1, 2, and 3 occurred at the defendant's Cohasset residence. Interview 4 occurred at the defendant's attorney's residence. A defendant's statements to a police officer are generally admissible at trial. When statements are those of the defendant himself, they are admissible as admissions of a party opponent. An extrajudicial statement made by a party opponent is an exception to the rule against the introduction of hearsay and is admissible unless subject to exclusion on other grounds. Here, the transcripts, okay, so it says properly authenticated transcripts may be offered in evidence or for identification as an aid to the finder of fact. And in this case, the finder of fact will be the jury. Here, the transcripts which were provided to counsel and exhibits at the motion to suppress should be admitted to aid the jury as the 4 recordings are several hours long. We watched a trial recently where the jury was provided with a transcript of the recording as they were listening to the recording. And I can't remember what case it was in, but I'm sure that you guys remember. The defendant's attorney in the federal matter was present at the 3rd and 4th interviews, and most of her statements are also admissible. Footnotes 3 and 4. Footnote 3 says Commonwealth proposes that the following comments by the attorney be redacted. And then they say the lines and the line numbers in the transcript. And the first one is discussion with attorney about a person being weird. And then the second one is the termination of the interview by the attorney. Statements authorized by a defendant or made by an agent of the defendant are not hearsay and are admissible as those of the defendant. The attorney was present as the defendant's agent, and the statements she made during the recorded interviews were made in his presence. Even if the attorney is not deemed to be the defendant's agent at the interviews, the statements are also admissible to provide a complete picture of the defendant's statements and to give context to certain remarks in the interviews. Oh, it was Adelson. It was the Adelson trial. Okay. Yeah, I think you're right. Right. They were given transcripts of those recordings of the cell phones, right? I mean, recordings of, the telephone conversations, I think. Footnote 4 says Attorney Miner represented the defendant at arraignment in Quincy District Court and was also counsel of record in this case prior to her withdrawal and the appearance of present counsel. Commonwealth's motion in Limine number 10 to admit the NCIC missing persons forms on Ana Walshe. Oh, so with regard to this, I would imagine that these recordings of his interviews would be admissible, although I imagine that the defense team may have some other things they want redacted that perhaps his attorney said more than what they wanted redacted, but we'll see what their opposition is to this, and then we'll see it argued on Tuesday. Commonwealth seeks to admit the NCIC missing person form for Ana Walshe that were created by Cohasset Police on January 4th, 2023. Police had contact with the defendant on January 4th, 2023, and used biographical information that he provided to fill out the forms, one of which was disseminated as the police searched for Ana Walshe. Okay. The missing person poster memorializes the statements of the defendant as to Ana Walshe's biological and contact information and is relevant to the state of police knowledge. We'll have to see if there's any opposition to that one. Commonwealth's motion in Limine number 11 to admit photos and a short video of Ana Walshe as she normally appeared. This is interesting. As grounds, the body of Ana Walshe has not been found, and evidence will show that the defendant dismembered her body and disposed of it. Items containing Ana Walshe's DNA were recovered from a Swampscott dumpster at the defendant's mother's apartment complex. Footnote 1, which says the defendant's DNA was also located on items in the dumpster, right? I can't remember which items were found in which dumpster, but it may be the Tyvek suit, the hacksaw, not sure. Excuse me for 1 second while I just go turn up the fan because it's getting hot in here. Oops, hold on. Come back to me. Here we go. All right, talk amongst yourselves for a second. I'll be right back. Don't get worried. I did not swipe myself out. I'm just going to go and turn up the fan. All righty. Among the items recovered from that dumpster were a rug with a distinctive pattern, a distinctive Gucci necklace, an Hermes watch, and a necklace made with colorful craft beads. The Commonwealth seeks to admit a short video showing Ana Walshe and her children on a distinctive rug at the Walshes' 516 Chief Justice Cushing Highway residence, an image showing her wearing the distinctive Gucci necklace, an image showing her with her eldest son while she was wearing the necklace made with craft beads, and an image showing Ana wearing her Hermes watch, an image depicting Ana, her eldest son, and the New Year's Eve dinner guest that was taken on December 31, 2022, and an image contained in business records of Lyft for an account associated with Ana's phone number. The short video and the images showing Ana with items found in the Swampscott dumpster are relevant to the identification of Ana Walshe. The image from New Year's Eve is relevant, among other reasons, to show Ana Walshe's physical condition, to corroborate testimony of the dinner guest, and to allow jurors to see the photo that WF received from Ana that night. The image from the Lyft records is relevant to Ana's identification as the user of an account associated with her phone number. The photographs are not inflammatory, were provided in discovery, and are relevant for identification and to show how Ana Walshe appeared prior to her death. It is well settled that a photograph may be introduced through a witness competent to testify that the photograph fairly and accurately depicts the victim at a particular time. Well, who are they going to use? Because Brian Walshe is not going to be forced to testify. What witness are they going to use to authenticate the photos of her? Her boyfriend? His mother? I mean, I don't know. Likewise, the Commonwealth may tell the jury something of the person whose life has been lost in order to humanize the proceedings, and a photograph may be admitted for this purpose. XOXO, Greg Connor. Again, stupid to put all of her personal effects and the rug in a dumpster somewhere and not think it's going to be found. I don't know. It'll be interesting to see if the photograph from that evening, because they're alleging, I think, that he did the crime after, on New Year's Eve, at some point after the guests left. And was she wearing that exact jewelry and that watch that evening? Be interested to know. Commonwealth's motion in Limine number 12 to admit evidence concerning defendant's federal charges. The Commonwealth moves in Limine for a ruling that some facts related to proceedings in the U.S. v. Brian Walshe, United States District Court for the District of Massachusetts, be admitted in the Commonwealth's case in chief. Here is the summary relevant factual background. Footnote 1. The Commonwealth is not seeking to introduce in its case in chief evidence related to the defendant's involvement in the probate of his father's estate, as documented by, in the matter of Walshe, the third, Thomas Moorcroft, Plymouth Probate and Family Court. In the probate matter, it was alleged that after his father died, the defendant destroyed his father's will and sought appointment to probate the father's estate. The Commonwealth requests leave to revisit the issue of evidence regarding the probate of the father's estate as redirect examination, cross-examination, or rebuttal evidence if the defendant makes that evidence relevant through cross-examination of the government witnesses or through direct examination of defense witnesses. This information has been provided through discovery. Yeah, we forgot about that. There were some shenanigans that went on when his father died, because he was pretty much, I don't know, maybe a con man, always looking to game somebody. Does it make him a murderer, though? I don't know. I don't know. He could be guilty as hell. I have no idea, but it just seems like the dumbest crime ever. The defendant is charged with murder, misleading police, and unlawful conveyance of a human body. At the time of the offenses, the defendant lived in a rented Cohasset house with 3 young children he shared with his wife, victim Ana Walshe. Ana lived in Washington, D.C., where she had, well, she didn't really live in Washington, D.C. I mean, she was back and forth, but the Commonwealth is saying she lived in Washington, D.C., where she had a highly compensated job at Tishman Speyer and commuted to Cohasset to spend time with the defendant and their children. Both the defendant and Ana expressed frustration with these arrangements, which began in the spring of 2022 when Ana was hired by Tishman Speyer. The defendant had been unable to move to Washington, D.C. with Ana because of pending federal charges for wire fraud, interstate transportation for a scheme to defraud, and unlawful monetary transaction in U.S. District Court for the District of Massachusetts. Among other things, the federal docket report shows that the defendant was arrested on May 9th of 2018. Attorney Tracy Miner filed an appearance on March 18th of 2021. The defendant pled guilty on April 1, 2021, and sentencing had been repeatedly continued. At the time of the offenses, the defendant was awaiting sentencing, subject to monitoring, and the government was requesting a committed sentence and hundreds of thousands of dollars in restitution. So yes, it is important to point out that Brian Walshe, at the time of these alleged crimes against his wife, Ana, was wearing an ankle monitor. We also found out through court papers and all of the investigative stuff that we've done on this case that the GPS monitor that Brian Walshe was wearing on his ankle did not monitor his location. It only monitored when he left his house. I ask you, what is the purpose of a GPS monitor on your ankle if it doesn't monitor your location? Isn't that the definition of GPS monitor? But I don't know. In December 2022, Attorney Miner was negotiating disposition with federal authorities. During recorded interviews with police after he reported that Ana left Cohasset on January 1, 2023, for a work emergency in Washington, D.C., the defendant told police that being apart was a stressor for them and that he had recently learned he was facing committed time on the federal charges. During the interview, he stated that Ana was upset at the thought of him going to federal prison for 6 months. The defendant said, after all of this, because we had been apart for so long, she's like, why do we do all of this house and running the townhouse and all the traveling this? What? Why do we do all of this house and running the townhouse and all the traveling this? Question mark. That's not a complete sentence, but that's what it says. Why do we struggle this much? I mean, the cost of and not being together. I remember her being very upset when I talked to her about it. And that comes from a transcript of one of his interviews. The defendant owed significant restitution, which his attorney wanted him to pay as soon as possible. Meanwhile, Ana had expressed frustration with her children not being with her in Washington, D.C., and told a friend that she and the defendant had a big argument over Christmas when she told him he needed to take accountability. Okay, who's the friend? She told a friend. Phoned a friend. He needed to take accountability for his crime and, if necessary, accept a committed sentence. Ana told the friend that she had only recently learned, that the reason her children were not with her in Washington, D.C. was because of the defendant and his lawyer. Ana told the friend that she had only recently learned that the reason her children were not with her in Washington, D.C. was because of the defendant and his lawyer. What? Did she ever ask to bring the children to Washington, D.C.? That doesn't make any sense to me. The Commonwealth's theory is that the defendant was aware that Ana was in a relationship with a man in Washington, D.C., realized that their marriage was likely to end, and that if the children moved to Washington, D.C. with Ana, it was much less likely that his sentence would be home confinement rather than imprisonment, and that he would inherit substantial life insurance proceeds if Ana was dead. Well, a couple things. Courts are hesitant to allow the non-custodial parent or even the custodial parent to move out of state with children, right? I mean, I don't know what goes on in Massachusetts in your family courts, but it is very difficult when you have shared custody for the children to be taken out of state and permanently moved. That is not something that is lightly granted. So there's that. Footnote 2 says, in addition to the federal criminal charges, the defendant was facing a civil suit in California as a result of the art fraud case. The defendant told police that he believed that he would not be sent to prison if Ana was not available to take care of the children. He told police, but that's all been put under suspense because of this. Okay. I have questions. If Brian Walshe is the dumbest criminal on the face of the planet, and he actually did take apart his wife's body and buy all these things at Home Depot, we know he did. There's video of him doing it. Wouldn't there be evidence on his phone? Because, he voluntarily gave up his phone and they extracted the whole entire thing. Wouldn't there be evidence somewhere on his phone that he knew that his wife was having an affair? And do they have that evidence? Because if he's dumb enough to make those Google searches, he also would be dumb enough to tell somebody that he suspected his wife was having an affair. And so I have questions. I will also tell you that I've heard from people who may or may not be in the know that there is another theory about Ana Walshe. And the theory has to do with what was going on in the apartment complex that I told you about in Washington, D.C. And that perhaps Ana Walshe was like, anybody ever watch The Americans? Ana Walshe was maybe like a spy. She had dual citizenship with Serbia. I don't know, but if this is going to be their defense at trial, but this is what I've heard. And that Brian Walshe was a dumbass, and that maybe Ana Walshe was involved with some very dangerous people. Anybody watch Black Rabbit? And so Brian Walshe was such a dumbass by getting himself into trouble with all of this stuff and the eBay and the probate and all of this stuff, that perhaps these very dangerous people came to Brian and said, listen, here's what's going to happen. Okay. Ana's coming with us and you're going to take the rap for this. And 5 years from now, we're going to release a video of Ana alive in Serbia. And then by that time, you'll be released from jail. But here's how this is going to go. You're going to do this, 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 and this, and this. And then, okay, well, more likely the Serbian mob says l'agent provocateur. Like that is like a legit concern, right? Could that be a legit concern? Because if you watch Black Rabbit and a lot of other, I don't know if the Sopranos had like people hacking off fingers. If you watch the last one of the seasons of You, Joel Goldberg chopped off his own toe to like make people think he died in a fire. And so, this piece of whatever it is on a hacksaw could really be from her. Who knows what these people were up to? There are dangerous people out there. We know that. We deal with these cases every day. And so the theory goes, Ana Walshe was picked up. She was scooted out of the country. And, the agreement was Brian Walshe is going to take the rap for this. And then later on, this is what's going to come to light. And then maybe he'll be as such freed at that point. So I don't know. Some people thought it was like a Gone Girl type situation, but here's all of the things that I'm pointing out to you about the admission that she was with a man in Washington, D.C. That other rabbit hole about what went on in that apartment building, just Google her name, Ana Walshe, Washington, D.C., apartment complex, and it'll come up. Somebody with far more time than I have will do a deep dive into that, and who knows? Federal case evidence that the Commonwealth seeks to admit. The Commonwealth seeks to introduce the following from U.S. v. Brian Walshe. The U.S. District Court for the District of Massachusetts, and they've got the docket number here. In May 2018, the defendant was charged with a wire fraud, interstate transportation for a scheme to defraud, and unlawful monetary transaction. On May 11, 2018, conditions of release were sent and a secured bond in the amount of $75,000 was set. FBI agents took buccal swabs of the defendant and Ana Walshe. Some people say buccal. I say buckle. It's both ways. It's a regional thing. Attorney Tracy Miner filed an appearance March 18, 2021. The defendant pled guilty April 1, 2021. A motion to continue sentencing was filed on July 13th, 2021. Notice of rescheduling of sentencing hearing was entered October 5th, 2021. Further sentencing hearings were held on October 6th and 8th, 2021, and June 9th, 2022. The defendant was sentenced on February 20th, 2024. So that was a year after Ana Walshe went missing, a little over a year after. That's when he was finally sentenced. And the sentence included a mandatory $300 special assessment and restitution in the amount of $475,000, for which $95,000 was deemed paid. Well, that's interesting. October 6th and 8th, 2021, that's when the hearings were, and June 9th of 2022. That was all before the disappearance of Ana. And then it took them almost 2 years to sentence him. Okay. Commonwealth seeks to introduce a redacted copy of the federal docket during the testimony of FBI agent Kristen Koch, who has knowledge of many procedural facts in the federal case, was present for many in-court events, and supervised the taking of the buccal swab of the defendant and Ana during the course of the federal investigation before bringing the swabs to MSP Crime Lab. Footnote 3, which says, a copy of the federal docket is attached. Commonwealth has highlighted the items it seeks to admit. And here are all the things they seek to admit. Leave that on your screen in case you want to look at it. Argument. Evidence of other crimes is not admissible for the purpose of proving bad character or a propensity to commit crimes. However, if such evidence is relevant for some other purpose, it is not inadmissible merely because it indicates the possible commission of another offense. 1. Evidence regarding the defendant's federal charges is inextricably intertwined with the charged conduct in this case and is necessary to present as complete a picture of the relationship between the defendant and the victim. Evidence of a defendant's prior bad acts may be used where the evidence of bad acts is inextricably intertwined with the description of events of the charged offense. Put another way, the prosecution is entitled to present as full a picture as possible of the events surrounding the incident itself. Evidence that the defendant was awaiting federal sentencing, owed federal restitution, and was facing incarceration on the federal charges is inextricably intertwined with the conduct charged in this case and is necessary to provide as complete a picture as possible of the relationship between the defendant and the victim. That because of the federal charges, the defendant was unable to relocate to Washington, D.C. with Ana provides context to the reasons the Walshes were living apart and to his statements to friends, family, and police about Ana leaving early on New Year's Day to return to Washington, D.C. for a work emergency. The defendant recognized that the federal charges were an essential part of the dynamic between himself and Ana. He brought the topic up to police interviewing him in the search for Ana, said it was affecting the entire family, and when the officer said he wanted to get a whole picture, the defendant said he did not want to hide anything that could lead to finding Ana sooner. The defendant said that Ana found it very difficult to be away from her family. The nanny who cared for the Walshe children and friends and family of the defendant and Ana were aware of the federal charges, and that because of the charges, the defendant could not move to Washington, D.C. with Ana. Footnote 4. In anticipation of sentencing in October 2021, friends and family members wrote letters to the court in support of the defendant. Oh yeah, I remember that. As the defendant, and also I have questions too. They have Ana's phone, right? And Ana's devices. So does Ana have communications with other people that supports all of these allegations? I need to know. These are things I need to know. And I don't know any of it yet. But I would think if they had it, they would put it in the papers somewhere. So I guess we'll get to it maybe if it's here. As the defendant repeatedly told police, the federal charges were the reason he and Ana were apart, as he could not move to D.C., and that was a significant stressor in the marriage. Footnote 5. And that, here's what he said on his January 4th interview. I've been having legal problems for many years now. That's one of the reasons why I couldn't leave, because I'm dealing with that now. But it was supposed to be done a long time ago, and it wasn't. So we've been really depressed about that. And there's a restitution that I get to pay, but we have the money, and we're just waiting to get a final resolution. So the stress was being apart and not being the authors of our own lives. I couldn't move when we had to. But yes, the biggest stress was not being together. Before, when I was dealing with it, we were together. It was fine. It was, it was one of those, and then we were a magnificent team. We were able to get through anything together. Specifically asked about his legal stress, the defendant said, I misrepresented a Warhol piece. You can read about it in the papers, So I had some art and then I lost money on it and I misrepresented it to another person, a gallery in LA. And then Then the FBI got involved and I was arrested, and that occurred in 2018. So I've been dealing with that. And then we went to sentencing in October 8th of 2021, and everything was going to be fine. After attributing his sentencing being postponed due to an issue with a bank, the defendant said, I'm kind of looked down here at the house. Kind of looked down here. You mean looked down on? Like she's looking down on him? Part of my sentence was home confinement, but it's gone over the 12 months because of things have not been resolved yet. And that's why I haven't been able to be in Massachusetts in DC with my wife. During the January 5th, 2023 interview, when asked if Ana ever talked about suicide, the defendant said, no. She never, ever said that. She talked to Jem for an hour and a half. I know you spoke to him, but about how the year had been and about how she was really unhappy with the trial, and things taking, or the court case taking longer and us not being able to be together. And she kept saying, I can come back. And then she's like, well, I can only have, 100,000 or, a smaller job. That is everything. I think that's in footnote number 5. Oh, no, it goes on. And I was like, no, we've made these huge sacrifices for you to be there. We have the townhouse. We'll stick it out. She was good to see a psychiatrist. It was the first time she ever brought that up, but I'd spoken to Jem about it today. He's spoken to me 8 times today and basically said, hey, that's fine. It doesn't mean there was any problems. It means she had a problem and that she was going to deal with it in a healthy way. So that was his experience. I think Jem was the guy who came over for dinner on New Year's Eve, if I recall correctly. I was overwhelmed by the 3 children and she was missing them. So it was a really bad situation. We discussed splitting them up, like TW would go with her. And I was like, do you want to split the kids up? And she's like, well, I could take all the kids. And I was like, how's that going to be for your job then? We did not have a good solution. During the January 7th, 2023 interview, the defendant and attorney Miner discussed the federal case, including that the defendant was trying to pay the restitution as soon as possible. When Trooper DeChico said he was trying to get a clear picture of the financial situation, the defendant said, just so you know, Ana's main thing was like, when can you come to DC? And the reason why I couldn't was because this is not resolved. She was like, why don't you come to DC? Then we'll just pay the bill. And I was like, it doesn't exactly work that way. Later during that interview, the defendant said during a conversation with Ana, he said, I know it's been tough being separated, And she's like, yeah, well, you have to get to, but her whole thing was like, you and the kids get to DC as quickly as possible. We had conversations about, the struggles that we're having being apart. And she's like, you and the kids have to get here as soon as possible. Not, there was nothing other than that. That was always her main focus. Later, he said, we agreed on, I have to get to DC. It just didn't feel like we were the authors of our own lives. That's why she wrote that on the thing. We have to be the authors of our own lives. We have to make this happen, Brian. We were always working together. And that is a long-ass footnote. As the defendant repeatedly told police, the federal charges were the reason he and Ana were apart and were a stressor on the marriage. And then came that very long footnote. During the interviews, the defendant said he was kind of locked down. Oh, locked down. I said looked down. Well, that's what they said in the footnote. I thought locked down. At the house because of the federal charges. This is highly relevant to the misleading police charge where he was subject to court-ordered monitoring. The defendant would have been especially vigilant about his whereabouts. That he was subject to monitoring on the federal charges shows that his false statements to police about where he went on January 1 of 2023 were not the result of accidentally or mistakenly not keeping track of his whereabouts. Attorney Miner's comments in the presence of the defendant suggesting that the ankle monitor, as part of the federal conditions, would corroborate the defendant's account also suggests the absence of mistake or accident in the defendant's recitation of his whereabouts. He was allowed to leave home to drive the kids to and from school and also to go to his mother's house. Buccal swabs of the defendant and Ana were taken during the federal investigation. The federal agents involved in that process should be permitted to tell the jury that the swabs were taken as part of an unrelated federal investigation. Otherwise, federal agents taking buccal swabs would be inexplicable and confusing to the jury. Well, remember what happened in the Karen Reed case? Judge Cannone was not letting any mention of the feds come in at all. The situation was a little bit different, so we'll see what the judge does here. Without evidence of the federal charges, which explained the reason the defendant could not move to Washington, D.C., and that hundreds of thousands of dollars were owed in restitution, the jury would have an incomplete and misleading understanding of the reasons Ana was living apart from the defendant and her children, the financial stressors faced by the defendant and Ana. The actions of Ana and the defendant would be inexplicable, and the murder of Ana would appear as an essentially inexplicable act of violence. Two, evidence related to the federal charges is also admissible because it's relevant to the defendant's motive, opportunity, intent, preparation, plan, knowledge, and the absence of mistake or accident. And all of those things are reasons why the defendant's other crimes may be admissible. Let's get into the facts because we are only halfway through the papers. That the defendant was charged federally, had pled guilty, was awaiting sentencing, and anticipating a significant restitution order is relevant to his motive, opportunity, plan, and the absence of mistake or accident. The defendant was facing committed time, but as he and Attorney Miner suggested, his being the primary caregiver for the children would be helpful to his sentence of home confinement rather than incarceration. But he never was incarcerated for those charges, right? Even after Ana's death. Now he's in jail for Ana's death. Evidence of insurance policies will show that the defendant stood to inherit substantial funds upon Ana's death. Funds that he could use to pay the hundreds of thousands of dollars he owed in restitution is relevant to his motive to kill Ana. Evidence that if he remained the primary caretaker of the children instead of Ana taking them to D.C. to live with her is also evidence of his motive and state of mind. But not if he was convicted of her murder. 3, the probative nature of the evidence of federal charges that the Commonwealth seeks to admit outweighs any risk of unfair prejudice to the defendant. And that is an argument that speaks for itself pretty much. XOXO, it says the federal charges are for nonviolent crimes. The Commonwealth requests that the court give limiting instructions on the use of the evidence about the federal offenses to offset any potential prejudicial effect and to focus the jury's attention on the proper application of the evidence, right? Like you're only to consider this with regard to his state of mind and the relationship between the parties. And knowing what we know about this judge, I think she's probably going to let it in. We'll see what the defense's argument is to keep it out. Commonwealth's motion in Limine number 13 to admit the victim's out-of-court statements as evidence of her state of mind and the defendant's motive to kill her. Oh. Well, these are for Ana Walshe's out-of-court statements. So let's see what they are. More facts. Ana had told her close friend AK, who lived near Ana in DC, that she had told the defendant that she had a crush on WF, the realtor who sold the Washington, D.C. townhouse to Ana. Ana and WF were having an intimate relationship. Ana had gone to Ireland with WF on her way to Serbia over Thanksgiving. Ana told the defendant that she had to work on Christmas Eve when she was spending the evening having dinner with WF and his friends. On Christmas Day, Ana's flight to Boston was canceled, So she drove to Cohasset. Okay, here's the thing. This can backfire on the Commonwealth, and here's why. Unless they can prove that Brian Walshe knew that she was having this affair, and I'm sure that if he knew, there would be evidence of it somewhere in his phone, right? And all of his devices that they illegally searched, in my opinion, and seized. Because if they can't prove through evidence in his phones that he knew that she was having an affair, doesn't this give her more of a motive to just disappear and do like a Gone Girl kind of thing, right? Because she blows her family off for Thanksgiving, and they're going to try and make the argument that she would never leave her kids. She blows her family off for Christmas Eve because she's out with her boyfriend and his friends, but she would never leave her kids. And couldn't that backfire on them? I don't know. I'm just spitballing with you here. On Christmas Day, Ana's flight to Boston was canceled, so she drove to Cohasset. From DC, she drove back to Washington. Okay. She drove back from Washington, DC to Cohasset, Massachusetts. I mean, how long is that going to take on a good day? On a good day. On Christmas Day, because her flight was canceled, there's about 1 million flights to Boston a day on all airlines from DC. There's a shuttle, goes every hour. That's weird to me. That's just weird to me. She missed all the other holidays with her kids. Why wouldn't she just take a later flight? That doesn't make any sense to me at all. Was she really somewhere more nearby than Washington, D.C., which is why she said that her flight was canceled and she flew home? It's at least an 8-hour drive on a good day. On a good day, it can take you 8 hours to get to New York City from D.C. on a bad day and going up, I think it's 95. What time was her flight? What time did it get canceled? Why was it canceled? Was there weather happening? Were all the flights canceled for that day? I got a lot of questions about that. The defendant contacted AK regarding Ana, and then Ana called AK and expressed frustration with the defendant as she had only been out of touch with him for 90 minutes. Ana and the defendant argued when she was home over Christmas, and Ana learned that her children were not with her in Washington, D.C. because of the defendant and his lawyer in the federal matter. Ana described the argument and the ultimatum she gave to the defendant to AK on December 29th of 2022. Ana also told AK that the defendant had told her that his mother was convinced that she was going to take the kids and run off with a guy in DC, and that Ana thought that the defendant believed this. Has anybody looked at the mother? Right. Why didn't she just take the Acela? Thank you, Josh H. Why didn't she just take the Acela? That's a lot faster than driving. What you see is what you get, says Christmas Day has little traffic on 95. My parents made the drive to Connecticut to North Carolina in one day. That's great. But if her flight was canceled, was it because of the weather? And if the weather was bad and it was snowing or there was a blizzard, I don't think it was going to be like a very short trip for her. So, I don't know, but I would love to see their communications from that day. Like, she's like, oh, I'm going to drive home now. I'm leaving now. And then what time did she get home? Like, there must be those communications on his phone too, right? Meanwhile, the defendant was researching divorce law, right? If you believe that he made those Google searches, what's the best state to get divorced for? What's the best state to get divorced in for a man or something? There was a Google search like that. And on December 28th of 2022, the defendant's mother hired a DC-based private investigator to look into Ana's infidelity. Is he gonna testify? Is the PI gonna testify about that? I have so many questions. Court Chopped says she spent Christmas with her cheat mance. Then Brian started reading her messages, her iMessages. Could be. Right. And Kate says, what do her communications with the boyfriend look like? Right. Like, can we just run away and be together? I don't know. I have questions. On the morning of December 30th, Ana arrived in Cohasset by plane. Oh, wait. So she drove up. She drove up on Christmas Day. I think she kept a car in DC, right? So she drove up on Christmas Day. And then at some point, she must have flown back to DC after Christmas. And then she flew back on the 30th, or did she drive back to DC because she wanted the car there? I don't know. There's a lot of pieces missing. So on the morning of December 30th, the day before New Year's Eve, she flew back to Cohasset, Boston. That night, she made an online reservation at an exercise studio, then canceled that reservation and sent an email asking about the monthly pass because she was going to be in the area more. What area? Boston or DC? They already said in these papers that she was already living in DC. On December 31st, 2022, that's New Year's Eve, Ana attended an exercise class at the studio. Okay, the studio in Cohasset. Then went to a salon for a pedicure. Ana spent New Year's Eve in the Cohasset home with the defendant and their children. Mutual friend GM, that's Jem, I think, joined them for dinner and left the house between 1 and 1:30 a.m. During the dinner, Ana was exchanging text messages with WF about their relationship. Oh, what did they say? That's the boyfriend. Ana and WF arranged via text message to celebrate the new year by having dinner on January 4th, 2023 in DC and discussing their long and short-term plans. On January 4th, 2023, the defendant called Ana's employer and was told to call police. The employer called Cohasset police. The defendant contacted AK, GM, and WF. Okay, so the boyfriend, the friend that came over New Year's Eve, and the girlfriend that she confided in to ask if they had information about Ana's whereabouts. Yeah, right. Mr. Monk's understudy says he had an ankle monitor on. I don't buy that he made the Google search about best states for divorce. And then there's an argument here, and we are getting short on time, so we're just going to scroll through. To see exactly what they want to come in. Evidence of a poor marital relationship between a defendant and a victim is admissible to show the defendant's motive to murder his spouse. Ana Walshe's statements to AK about having told the defendant she had a crush on WF, that the defendant believed his mother's report that Ana was going to leave the defendant for a guy in DC and take the kids, and that Ana and the defendant had a big fight over Christmas and gave him an ultimatum about accepting jail time are admissible to show Ana's state of mind and the defendant's motive to kill her. They still got to close the loop of him knowing about the affair, right? I feel like I'm missing something here. Like, you got to close that loop that he knew. Maybe the mother had her suspicions and did her little motherly thing behind her back. Like Wendy Adelson had nothing to do with the death of Dan Markell, right? And it was all Donna and Charlie. I mean, it happens, right? And they kept Wendy out of the loop. Like, I don't know. Like, maybe the mother had her suspicions. She's like, I got to confirm it first before I lay this on Brian. Because, poor Bri has a lot of issues with his ankle monitor and his con man ways and stuff. So I don't know. So again, they talk about Ana's in-depth conversation on December 29th with her friend AK. And it's kind of repetitive as to what we read before. That Ana gave the defendant an ultimatum saying that she wanted her kids in DC, that he had to take responsibility, that she wanted him to do whatever he had to do so the family could be together, even if that meant serving his time in jail. But I mean, do you really believe that Ana, if she was having an affair with this man that she was so close with that they went to Ireland together and they spent all their holidays together, that she really wanted Brian to be together with her? I don't know. I don't know. A lot of shady Brians in that area, right? Ana and AK talked at length about how upset she was that his lawyer was the one who decided the kids be with the defendant and not with Ana in DC. Ana wanted the defendant to be responsible and be accountable. Ana told AK that she said to the defendant that she had been living in another state. The house is in her name. They had been physically separated. Well, the house had to be in her name because if it was in his name too, then, there's a federal forfeiture law, as you know, because we read about that yesterday when we went over the federal indictment of Howie Rubin and Jennifer Powers, which is pretty disgusting. So it had to be in her name only. She also told AK they had been physically separated and the Massachusetts law might already see them as separated and that she could just take the kids. Yeah, I don't think that's how Massachusetts law works. I'm not a family law attorney in Massachusetts, but I don't really think that's how it works. You can tell me if anybody here has been divorced in Massachusetts or was in a custody battle. Is it okay for them to just take the kids to Washington, D.C. from Massachusetts? If the law sees you already as separated, I don't think so. AK described Ana as uncharacteristically distraught. He had been on house arrest awaiting sentencing of jail time or not. In Ana's mind, the defendant had to do whatever to end the case, even if that meant going to jail. Well, this is interesting because I pointed this out before, professor in mathematics and science, and here's what I'm thinking. Professor in mathematics and science says, OMG, just think if it was she that made these horrible searches to frame him, not that I really believe that, but it would be so crazy. Well, here's the thing. The searches were found on the son's iPad. The son is 6. And I've had this question from the beginning and I still don't have an answer to it. If, what do you call the Apple ID? If Ana's Apple ID, right, was signed into that iPad for the son, because I'm sure the son didn't have an Apple ID. He was 6. And she made those searches from any other device. Wouldn't they show up on the iPad? And I have questions. And if she was a spy, like some people seem to believe, couldn't it be done that way? And so, yeah. And the searches are pretty stupid. Lindsay Clancy's pretrial is today. What time? Is it at 2 p.m.? Oh, I think I have to be on the on mommy Uber duty. Thanks, Joanne. Court Shop said he'd have to be logged in to read her texts. He had her password. Apple products say where the device is logged in. No mention of out-of-area logins from Guarino. Well, Guarino's not the brightest bulb either, is he? Just thinking out loud. Maybe she didn't go to DC. Maybe she stayed local. I don't know. Moving on. Ana also told her, the defendant told her that his mother was convinced that, Ana told AK that Brian told Ana that his mother was convinced that Ana was going to leave Brian for some guy in DC and take the kids, and that she believed that Brian believed that. Okay, so, I mean, I can't even count double, triple, quadruple hearsay. And so the argument goes on for another couple pages. The defendant's awareness is shown by, among other things, the December 28, 2022 hiring of a private investigator to investigate Ana's infidelity by the defendant's mother. So the defendant's mother did something and you're imputing the defendant's mother's actions, the awareness of his mother's actions back to him. It doesn't work like that. It doesn't work like that. You need more. You need more. The defendant's research of divorce laws on December 27th of 2022. Again, I keep repeating myself, but and evidence the defendant was able to see messages intended for Ana on his phone, and Ana was exchanging text messages with WF on New Year's Eve. Well, that could have set him off. Footnote 1. In the first recorded interview, defendant told police that Ana's iMessenger came up on his phone and he could see messages intended for Ana. That's just weird. How does that happen? How does that happen? And was Ana not smart enough to prevent that from happening? Because I have questions about that too. If she's having an affair, you think she's not dotting every I and crossing every T and communicating with him on something like Signal or WhatsApp or one of those kind of things? I don't know. Court Chop said Miner said the PI was hired after Ana was missing. I can't remember now. Evidence that Ana told hey, she told the defendant about her crush on W. Really? She's going to say, I have a crush on this guy and I'm having an affair with him. I mean, I have a crush on him, but I'm not having an affair with him. So, if you see any iMessages that look suspicious, that's just because I have a crush on him. Really? Is admissible to show that the defendant was aware from Ana herself about Ana's attraction to WF. Oh, and then they want Ana Walshe's statements and text messages with WF are admissible to show Ana's state of mind and the defendant's motive to kill her. This is a reach, but let's see. Commonwealth seeks to introduce portions of text messages Ana exchanged with WF, the boyfriend, from December 29th to December 31, 2022, and text messages WF sent to Ana through January 5th of 2023. Footnote 2. The absence of any response from the victim to WF's messages is relevant as the defendant claims she left for a work emergency in Washington, D.C. The text messages contain the names and faces of WF's minor children, which the Commonwealth intends to redact as the minor children's identities are not relevant to any matter before the court. Had she met his children? Because that's a serious relationship. If he's introducing her to his children, that's a pretty serious relationship. And that would give motive for her wanting to run away with him and covering tracks. I don't know. This is just spitballing here. Right. Crime Genie says it's funny how the Commonwealth is fighting hard for text messages, but they didn't care in the Karen Reed case. Sean Wilson says WF is her mob handler. Oh, that puts a whole new spin on things. Laura Davidson says the Google searches were made before she left the house, with the 2-foot duffel bag and a Prada purse. Details a 6-year-old supposedly said. No 6-year-old ever gives that detail. 50 Shades of Blue says she had her kids' bedrooms all set up in DC too. Oh, Massdad says regarding Lindsay Clancy, the habeas says 4 p.m. defendant to appear by Zoom. I could be back in time, Massdad. All right, let's cover. Oh, wait. And then, okay, but I'm going on Justice Serve at 6. I can do it all. Today's going to be a busy day. It's going to be a busy day. I don't think it'll be more than 2 hours, right? Or Chloe Bit, so we must have quit, says the searches aren't even real. I don't trust Guarino and company. These messages show that Ana was in a serious romantic relationship with WF. They texted about love, being intimate, and planned to discuss their long and short-term goals when Ana returned to DC, and that Ana would celebrate the new year with WF on January 4th. This could all backfire. The evidence will show that the defendant was aware of Ana's relationship with WF and her text messages with WF. Among other things, the defendant told police that Ana's iMessenger came up on his phone and he had some access to her Instagram. He was researching WF's name on December 25th of 2022, looking at pornographic websites relating to cheating wife. Oh, come on, really? And was researching divorce. Okay, so his corn search for cheating wife is evidence that he killed her. That's the first time I'm hearing this. Anyone? Bueller? Anyone? It's not a thing. Jen and Toxic says it's not a thing. Skybell says I had a bad mother-in-law. If you want to talk about corn, just put like a corn emoji in the chat because we're not allowed to say that word under RuleTube laws and regulations. They don't like it because they think we're promoting it. But it says right there, looking at pornographic websites relating to cheating wife. Okay. All right. Well, that seals the deal then. Thank you, Mastad. He told police that Ana's messages sometimes appeared on his phone, and he called WF on January 4th, 2023 to ask if WF had information of the victim's whereabouts and was aware that the victim had texted a photo to WF. If he's researching divorce, then why does he all of a sudden pivot to a hacksaw? Please, someone explain that to me. I don't know. Maybe I watch too many spy shows. Ana's statements to GM on December 29 and 31 about her relationship with the defendant are admissible evidence of her state of mind and defendant's motive to kill her. Ana had a lengthy conversation with GM by phone on December 29th and invited him to have dinner on New Year's Eve at their house. During the December 29th, 2022 conversation, Ana alluded to a relational issue. Alluded to it. She didn't actually say it. Told GM she was very fatigued about the defendant's legal case and that there were certain things that the defendant had not done for the case that were upsetting. GM reported that Ana said something about the defendant's attorney. Is this the case? Remind me, chat, because I sometimes conflate my cases. Where Cohasset PD got an email from a guy saying, we have Ana. And then it was like from a Gmail account and like it's been mentioned in passing a couple of times. And then I don't know if it was ever really even investigated. $50 Shades of Blue says, Melanie, I was at Brian Walshe's house, took pictures and videos, can see what CSI did. Also, only entrance out of the basement to load bags into car. Also, yard, pool, living room, and luminol on the staircase. Can you email me? My email's in the show notes, but it's fanbase@mlittlelaw.com. I would love to correspond with you. And Jen and Toxic reminds us that just because you're paranoid doesn't mean someone's not out to get you. There was a ransom demand. Yep. This is the one. There was a ransom demand. They were writing in code. Yes. Yep. Yes. I don't know. Does anybody think that Ana Walshe could still be alive somewhere? Is it just me? Not lovers, but mafia? Fam, says Helena Frost. The defendant was aware of Ana's state of mind as Ana related to AK. She and the defendant had a huge fight over Christmas, moving on and on and on and on and on. Additional evidence of Ana Walshe's state of mind may become admissible to rebut any claims made by the defendant. A murder victim's prior out-of-court statements also may be admitted at trial to prove the victim's state of mind, where the defendant makes it a material issue. So we reserve the right to introduce other stuff if the Commonwealth says the Commonwealth is not privy to any theory of defense that the defendant intends to present. If the defendant makes Ana's state of mind a material issue, among other things, the Commonwealth will seek leave to introduce Ana's statement to WF that she did not know what the defendant was capable of if he learned about Ana's relationship with WF. Also, maybe she was involved with some really dangerous people. Maybe she was involved with some really dangerous people. Right. Rainy Day says, what would explain him buying a Tyvek suit, saw cleaning supplies, etc., after she disappeared? Well, the rumor mill has it that these very dangerous people said to Brian Walshe, here's what you're going to do. And here's what you're going to do. And you're going to take the fall for this because you're a jackass and you got yourself, in trouble for selling the Andy Warhol paintings. And 5 years from now, we're going to release a video of her alive and you'll get out then. I don't know. I don't know what she was involved in. I'm just telling you what I heard from some people who might have some inside information. That's all. It's just a theory. I don't know that the defense is going to use it at trial, but that could be the thing. Could be the thing. But why? Because she's involved with the mob and she has secrets? I don't know. Why do the spies care about his crimes? Well, I'm just spitballing here because he's a jackass and he got himself involved in all of that, which brought attention to all of this. And so they had to get her out of the area. I don't know. Listen, I have no idea. I'm just saying it could happen. We're up to number 14, motion in limine number 14. So this is going to have to be a continued stream that we're going to have to come back to. And so we will come back to it because we're going to pivot over to do Aiden Carney's case at 12:30 and the supplement to the mega motion that I have for you. And Betsy says, I just squealed when I got your live notification. I'm substituting 6th grade math today. Lord help me. Oh, girl, shouldn't you be paying attention to those 6th graders? That's hard. Middle school is hard. Thanks for your 20. Colleen became a new member. Welcome. Olive J. Nichols says, when I got divorced in Massachusetts, the judge would not let me leave the state. Right. Thank you, Olive J. Nichols, for your 5. And Weird Debbie M says, thanks for all that you do, Melanie. Thank you for being here for 5 months, Debbie M. I don't think you're weird at all. And Miss Jessica says, love being here with all the cupcakes. And you, Melanie, come visit those of us in Chicagoland. I don't really have any reason to go to Chicago right now, but if I do, I'll let you know. Somebody says, if she was involved in international criminal activity or a spy, it would make far more sense for Brian Walshe to be deleted to get out of the way than Ana, says Zoe B. Shelly says, Brian taking the hit for the Russian mob, says M. Cater, 5150. Shelly says, one thing we can all agree on, Brian Walshe is a jackass. Robin Rose says, if Ana was a spy, Brian's crimes would have really ticked them off by bringing attention to Ana's financials. Thank you. Thank you. That's what I'm thinking. I don't know. And Josh said, Zoe, because those types of people have connections in jail. Oh, good. Thanks for bringing this up. JC the Music Man says, doesn't the buffer zone tell us all we need to know? Here's an important point of that buffer zone motion. The buffer zone motion was made by the Commonwealth, and I think I went over that during yesterday's show. I don't remember because all the days are blending together. It is important to note that the Commonwealth does not think that there's going to be supporters or protesters out there for Brian Walshe. They were concerned that if Aiden Carney has a hearing during the time that the Brian Walshe trial is going on, that they should be put behind a buffer zone so that they are not, the jury does not come into contact with them. So the Commonwealth was not concerned that anybody was going to be there supporting Brian Walshe. That is not the case. It is, they were worried about Aiden Carney. Okay. Does everybody get it? Thoughts, questions, comments, concerns before we teleport on over to talk about the supplement to the mega motion. What do you think? Kathleen says, did we not go through the buffer zone with Karen Reed and they fought it to the end and was able to stand outside? What is the point in this? Well, there was a buffer zone for both motions though, right? People had to stand outside, but they had to stand outside the buffer zone. And so it was because of, well, they're worried about protesters or people coming into the courthouse for Aiden Carney. And so there's that. And Limine says, hi, y'all. No questions, but a lot of concerns. Boston Bay Forever says, worried about hecklers for Proctor. Well, the thing is, they're not calling him. They're not calling him. In fact, they want all evidence of his improprieties, bias, termination, internal affairs investigation, post-commission hearings, all of that to be excluded from the Brian Walshe case. Not calling him or nothing. Slice and Dice Intent says, was she skimming from someone? I don't know. Did her financials come in? I don't know. Well, but here's the thing. Aiden Carney's next hearing is December 5th, so it's moot. It's going to be moot. If the Walshe trial is concluded before December 5th, it's a moot. And the motion said, in the event that there is going to be a day, then would you please do this? And that we only saw one side of that motion, only the Commonwealth side. So there's that. All right. Buckle your seatbelts. I'm going to teleport you over to the 12:30 stream. Hang on. Mass Dad says, my kid is a middle schooler. My name is now Bruh. Thank you, Kate, for thanking me and the mods for going over the papers. I don't know. Their kids went into state custody. Are you talking about the Walshe kids? At the time that this happened, they were, I think, 2, 4, and 6. I don't know. I don't know about that. I don't have any knowledge of that. Aiden Kearney. Yeah, Aiden Kearney. Oh, Lisa, the backpack, we bought a Hannah Montana backpack on eBay for $30. Problem solved. Thank you for asking. You guys were so helpful. You were so helpful. If you guys don't know and you've got kindergartners or preschoolers, you better save that backpack, because the new thing is that the seniors in high school use their kindergarten backpack for their senior year. So there's that. Tom Gully Show says, Brian Walshe getting his 15 minutes of fame after misrepresenting a Warhol painting is ironic. It is. Yeah, I thought the kids were being cared for by somebody's grandmother too. And so I don't know that they're in state custody. So I don't want to spread false information because I really just don't even know the answer. All right. Everyone go get a drink, go get your popcorn, go get all the things that you need for the 12:30 stream. Thank you to the moderators. Smash the like button on your way out and then smash the like button on the way in so that we can talk about the supplement. The supplement. All right, my friends, stay cool, stay kind, stay classy, stay safe, buckle your seatbelt because we're going on over to the 12:30 stream. And also, thank you to Gail, who says, best safe zone to be. Well done, Mel Moz. Thank you very much for being here for 14 months. I'll see you in 3, 2, 1. Peace.